wholesome debate, and I have thoroughly enjoyed it, except that I'm the one sitting here. I'd like to say that with respect to the objection that the matter before us is sub judice, I think that when the standing order referred to said that a matter that is sub judice shall not be inquired into by this House, it could not have meant that we had our mouths gagged, completely our hands tied. And so each case will be decided on its own peculiar sets of facts and circumstances. And the question is, as I have read extensively both out of Australia, New Zealand, and England, you have to go on to show that the debate or discussion will prejudice the outcome of the matter before the court. So ipso facto, just having a writ file or a motion file cannot and should not bar the National Assembly from discussing a matter. If it goes on to try to make a ruling that the court is being asked to make at the same time, I think that would be wrong. The court is asked to set aside a no confidence motion by this House, passed in July. There are no ancillary orders sought, not that I think they could be granted, restraining us from doing anything else. So I am of the opinion that the matter is not sub judice to the point that it cannot be discussed. We come to the second limb of the objection, and that is that it violates the member's right to freedom of expression. I believe that independently a person has a right to freedom of expression, and that right should only be taken away as prescribed by the Constitution, and I think the Attorney General listed the different areas on which that right could be taken away. But then the member before us is not just an ordinary member, he's a minister. And so this House has its own rights and its own regulations and procedures as well. And so the question is whether the House has any authority or power to regulate the conduct of its own members. And again, I am satisfied that this House does have that authority. As I said, I've been reading extensively, and even a few minutes ago, I think I quoted from page 89 of Erskine May, and I'd like to quote a bit from what I've been reading. In the case of Bradloff and Gossett, I'm quoting from page 89 of the second edition, an 1884 case. The question arose as to whether the member Bradloff would be allowed to participate in deliberations in the House. He was forbidden because he refused to take an oath. Took the matter to court, and the court, Justice Stephen, ruled and declared that even if the House of Commons forbade a member to do what statute required him to do, in order to enforce the prohibition, excluded him from the House, the court had no power to interfere. The House of Commons is not subject to the control of the courts in its administration of that part of the statute law, which has relation to its own internal proceedings. Even if that interpretation should be erroneous, the court has no power to interfere with it directly or indirectly. Goes on to say, lower down on the page, and quoting Justice Stephen again, it would be impracticable and undesirable for the High Court of Justice to embark on an inquiry concerning the effect or effectiveness of procedures in the High Court of Parliament, or an inquiry whether in any particular case those proceedings were effectively followed. And later down, there's a case of British Railways Board against Picken, 1974, appeal cases 765. Parliament has to be left in unfettered control of its own procedure. So I accept that we have the right to regulate our own procedure, and the court has the right to do what it has to do, but we have the right to do what we have to do. It comes down to the question I posed, whether or not the procedure invoked to sanction the minister is appropriate. I believe that the motion is properly before the House. Motion in the name of the Brigadier. Party in this House, side of this House, alone or together, require my resignation or express no confidence in me, I'm prepared to go. I do believe that as Speaker, I have a duty to ensure that the rules and procedures of this House are respected, enforced, and followed. At the same time, I have a duty to protect majority and minority. And so I believe that, notwithstanding what may have been decided on in previous cases, particularly the case cited extensively of Jagan versus Speaker Gadraj, I believe that a member who comes up for sanction, which is the punitive arm of the House, which I believe the House has the authority to issue sanctions, has a right to be heard. I do not share the view that his address from the floor during the no confidence motion equates to a right to be heard at the stage of sanction. Those of us who practice law know that anyone and everyone who is accused of anything or who faces any punitive sanction has a right at least to be heard in his or her own defense. And if he or she feels incapable of conducting that defense, they have a right to solicit assistance. In that regard, having accepted that the motion is properly before us, I am going to, as I said, make an unpopular rule, and it has two parts. And the first part is that I believe that the motion properly brings before this House for the first time in many decades, and particularly after we gained independence, and now with a written constitution, it brings to the fore the powers and privileges of this House. Because what happens to one member affects not that member, but this entire House is affected by that. So how we treat with 1 or 10 or all 65 members brings the entire House under the spotlight. And so for that reason, I believe that the matters raised in the motion are matters which should be referred to the Committee of Privileges, Arms Amendment Bill, pending a report from the Committee of Privileges. That is my ruling on this matter. And on that note, we may either proceed or take a short suspension. What is the wish of members?
Speaker.
Mr. Moore.
With your indulgence, Mr. Speaker. The members of the Alliance for Change accept your ruling on this very contentious and controversial matter. And we will, with your guidance, take those measures that will allow the fullest distillation of this controversy. On our part, we are not happy that we are caught up in a game of Rohee roulette, where it appears as if one honorable member of the House is a single bullet in the chamber that would shatter our parliamentary democracy. And therefore, we do not feel that this is an issue on which this Parliament should die. The people out there, we have a responsibility to the Guyanese people, and we have duty to perform on their behalf. And so we want to ask that we veer off from the precipice of self-destruction and gridlock, and that we take the only sensible path of having some political space in which we can diffuse the tension, have the lives of the people of Guyana be pursued as best as they could in this period that is coming down with due time. And so I believe that the ruling is one that should inform us that we should not go to the precipice of a gridlock. We should back off. So, Your Honor, I can assure you on behalf of the Alliance Alliance for Change, I nearly said Alliance for Progress because it is really an Alliance for Progress, that we have no intention, no contemplation, no cause whatsoever to express any no confidence in Your Honor, and that we fully abide by your Speaker. We have full confidence in you.
We accept your ruling, Speaker, but on a point of clarification, is it that the Speaker is ruling that whilst the matter is with the Committee of Privileges, the honorable member shall not speak in relation to any matters? That's it. With respect to the functions of the Minister of Home Affairs. And it cannot just be clarified. So suppose it next year to bring another Home Affairs bill.
While this matter resides in the Committee of Privileges, it is a matter that concerns this entire House. All of us have a duty to ensure that we take the right and proper steps. I recognize the right of Mr. Rohee to address the House. Any bill that comes or initiated by him, I will not recognize.
He will not speak.
We can move to the